If your spouse owns their own business, are you entitled to a share of it in a divorce? And the answer is yes. Equitable distribution is the statute in New Jersey that divides assets and debts for a married couple. If a business was commenced during the marriage, the value of that business is subject to equitable distribution. There are legal rights in a business and there are equitable rights in a business. If you happen to be on the books and records as an owner or shareholder, then you have a legal interest in that business. If you are not on the books and records, then you have an equitable interest in that business. And again, the equitable distribution statute has 15 factors that a judge looks at in dividing what share a spouse receives from a business. There also can be a situation where a business is premarital, and a certain portion of the business could be subject to equitable distribution, specifically the increase in value. And there's a distinction between a passive increase in value and an active increase in value. A passive increase in value is not subject to equitable distribution. An example of a passive asset is a stock. Let's say you bought IBM at $100 a share and it went up to $110 a share during the divorce. Because that price went up $10 due to the market, that is a passive increase, and therefore a spouse would not be entitled to the increase. A spouse is entitled to the active increase in a business. That would mean the value of an asset as of the date of marriage through the date the complaint for divorce is filed. An active increase is when a spouse utilizes their actions or efforts in increasing the value of a business. In other words, whether it's a doctor's office, lawyer's office, carpenter, plumber, because that spouse is going to work every day and building that business, that is what we call an active increase. So therefore, a spouse would be entitled to the increase in value from the date of marriage to date of complaint for divorce.